Hello, everyone, ladies and gentlemen. I think it's time to start our panel on war and migration. My name is Patrycja Matusz. I am Vice Rector of the University of Wrocław, and it's my pleasure to welcome you on the University of Wrocław. I hope you enjoy, and I heard already that you enjoy the time here in Wrocław, and that the conference is very interesting and the discussions very hot. So we hope to have the same amount of questions after our great presentations. Please allow me to say a few words about the panel, our panelists, and about current migration situation in Poland, because probably, as you know, this is the subject widely discussed in the last weeks in Poland. As a migration researcher, the last weeks were kind of difficult for me, not only because of the new research challenges, but also because of the involvement of all of us from the migration research area in the supporting Ukraine and Ukrainian migrants in Poland. This is a very special moment in the history of the relations between Ukraine and Poland, and I'm sure also the response to the migration crisis would be a part of the history books in the future. Just a few words about the numbers. Starting from 24th of February, after the Russian Federation aggression on Ukraine, 3.8 million migrants or refugees crossed the Polish border. We can estimate that by the end of June, the number of people who stayed in Poland is about 1.2 million. This is a very specific group, demographic structure of the group that we talk about. 47% of this group are children and 42% are women. So we have a little bit different situation than in other migration crises that we have been analyzing in the last years. If we can say a few words about the concentration of these migrants in Poland, the majority decided to stay in the big cities due to various reasons. And what is very important and also interesting from the analytical point of view, in the last weeks we have been observing the higher outflow of people, so people returning to Ukraine, than new migrants arriving to Poland. To sum up, I would say that the crisis, the migration crisis, due to the invasion on Ukraine, has been managed in Poland mainly by the civil society. I call it the grassroots humanitarianism, because 70% of the Polish citizens engage in various ways in the support for Ukrainians. Almost 90% of refugees in the first weeks found shelters in the private flats and houses, which is also different in comparison to the previous crisis. What I can say about this group, 1 million Ukrainians already registered for the Polish ID number here in Poland. And according to the Ministry of Family and Social Policy, over 20% are already economically active. So this is just a few numbers and information about the current situation, which, as I said, is close to my heart due to my research interest. But today we are going to speak about conflicts and the potential causes of migration. We would like to say a few words about the forced migration and its implication for the processes of for international and national legislation. We have the great panelists, so I hope we also touch the context of the European Union. And of course, we cannot avoid the question about the selective approach to different categories of migrants. I hope we also say or ask the question about the directive on temporary protection, which was introduced by the European Union. And And I have a lot of questions myself, but of course, I warmly ask you to prepare all your questions for our panelists, and the podium would be open. I promise not to take too much time. Okay, let us start with our panelists. I would like to introduce Mayra Feddersen from the Universidad Adolfo Ibañez from Chile. Hello. She is the Deputy Director of the Center for Study of Law and Society. She focuses on the cultural factors that influence the formation of law in Congress and the development of regulations in different bureaucratic organizations in the executive. But today, Mayra is going to talk about the relations between immigration and public law and the evolution of immigration in the South America. Welcome. Now I change for a man. So welcome Jorrit Rijpma, sorry, I speak Dutch, so University of Leiden. Professor of European Law, Jean Monnet chairholder and the head of the Department of European Law at Leiden Law School. His research focuses on so-called area of freedom, security, and justice, looking specifically at the link between security and mobility, which is important for our panel today. Jorrit is going to give us a broader picture about the responses of the law to the crisis and migration. And last but not least, Carmen Perez Gonzalez, Universidad Carlos III de Madrid, an associated professor of public international law, advisor for international affairs at the cabinet of the Spanish Secretary of State for Migration, and the member of a management board of the Fundamental Rights Agency of the EU, so very experienced in migration area. We would like to start with Jorrit, so the floor is yours. I gave them 12 minutes. I have my magical 5 minutes poster, so please not extend your time because we want to have keep time for questions. Jorrit, the floor is yours.
Thank you, and I'll try not to speak too fast. So, good afternoon. Thanks for having me here in beautiful Wrocław. I don't know if I pronounced that correctly. It's a great pleasure. This is my first Icons. I hope it will not be the last. I think it was yesterday that Professor Weiler compared himself to the understudy of Pavarotti. If that is the case, then I'm the sunflower in the primary school musical. But nonetheless, I hope I'll be able to give you some of my ideas on this panel, which was called Challenges of Migration to Public Law. Now, the figures are well known. International migration has increased in the past 5 decades, and today there are around 281 million migrants. And what is more, at the end of 2021, so before the second invasion of Ukraine by Russia, there were already 89.3 million forcibly displaced people, and that is more than double the number after World War II. And most of these people find themselves either in their countries of origin as internally displaced people, or hosted in neighboring countries. There's this misunderstanding that most refugees would find themselves in Europe or America. And the drop in numbers, both in migration and refugee applications that we saw during COVID-19 seems to have been temporary, as numbers are steadily on the rise ever since restrictions have started to ease. So how to deal with the global crisis of mass migration, because that is how it was phrased in the description. Perhaps we should state it in more neutral terms. How should public law regulate migration and asylum in the 21st century? And rephrasing the question obviously doesn't provide an answer, if there is any. But what it does do, it takes the crisis element out of the equation. And I think that is important, because most of the time the real crisis is not the phenomenon itself, but the way it is being portrayed and the way it is being handled. And if we think back about what has widely become known as the 2015 migration crisis, we must conclude that if it was a crisis at all, then it was first and foremost an internal political crisis for the European Union. I think that is also confirmed today. Despite much larger numbers, the swift and rather generous response by the European Union to the displacement of Ukrainians means that there is actually very little talk of a Ukrainian refugee crisis. And compare that to the relatively small numbers of people that were stuck at the Belarusian border only a few months earlier. This led to the imposition of the state of emergency in 2 EU member states and border closures in clear violation of EU and international refugee law. Migration is inherently complex and a very messy social reality. Let there be no mistake, the idea of safe and orderly and organized migration is an ideal, but it is far removed from the reality and the experience of many that have left our homes in search of a better future. And I think it is important to emphasize that those that argue in favor of draconian border and migration controls and those that advocate against those are both mistaken in what law and law enforcement is capable of in liberal democracies. The movement across borders of people is not fully uncontrollable. It's not a force of nature, but at the same time, there is a limit to the extent that it can be steered and controlled. So what are the challenges to public law in regulating migration and asylum? On the one hand, there's a range of new societal developments which will either need to be accommodated in the existing regulatory framework or for which new rules need to be put in place. And on the other hand, there's a number of more familiar challenges which often reflect tensions that public lawyers more generally face. Now, in the first category, the obvious example is, of course, the COVID-19 pandemic and how do we respond to that and the aftermath thereof. But there's also the rise of technology. Think about artificial intelligence, surveillance, and information sharing. There is the privatization and outsourcing of migration control. Violent conflicts, such as in Ukraine, but also in the Horn of Africa or in the situation in Venezuela. There is environmental degradation and climate change, the effects of which we are still to see. And there's the rise of anti-liberal regimes and the instrumentalization of migration. So these are the societal developments, I would say. And then in the second category, I would start with the tension, which is an old tension, between the right to leave one's country versus the right of a state to control its borders. And there, what we see more recently is an emphasis not just on that sovereign right to control borders, but also on national security, which is linked, but to me shows that is the accumulation of years of securitization of migration. We also see a shift from legally binding instruments to the informalization of migration law. This is clearly visible in the negotiation of the global compacts, but it's also visible, for instance, in the external relations of the European Union. The EU-Turkey statement is a very clear example. And this, of course, raises all sorts of questions in terms of democratic control as well. How do you check what is being done under the gentlemen's agreements and the manifold memoranda of understanding that there are? And then bringing it a little bit closer to home is discretion versus legal certainty. Discretion of the executive is increasingly reined in by both the legislator and the judiciary. And many will assume, and sometimes this is also the case, that this will lead to a better position for the migrant. You know, you don't have this unfettered discretion anymore of the executive. But if I look at the developments in my own member state, in the Netherlands, what we see there is that the restrictive migration policies and laws of the past decade have actually limited so very much the discretion that the judiciary and the executive have. I think someone has a phone call, right? Yeah? Oh, I have 5 minutes. Whoa, there's phones going off, there's 5 minutes. This is very stressful. I will speed it up. Synchronized. So what I wanted to say is that in the Netherlands, what we see is that the discretion is so very much circumscribed by legislation, and actually this has been accepted by the judiciary, that it is very hard to do justice in individual cases. That brings me to the position of the individual versus the state in procedural migration and asylum law. Many systems of administrative procedural law regard the individual as an equal party in proceedings, certainly in my country. But the individual is inherently in a weaker position, and cuts on legal aid have only made that worse. And what is more, if you look at the burden of proof in administrative law for the executive, it's much lower than in criminal law. There is no equivalent of in dubio pro reo. And yet, at the same time, there's a cost-benefit argument to be made, because what if the price of increased procedural fairness comes at the efficiency and the functioning of migration and asylum systems? And lastly, there is the territorial versus the extraterritorial exercise of power over migrants and refugees. What does the projection of state power beyond the national border mean for the applicability of human rights instruments and the attribution of responsibility? And that is a question that becomes even more difficult in systems of multi-level governance. There's been a lot of attention for that in the framework of the EU, but it applies more generally to cooperative arrangements between states, international organizations, and private actors. Now, some pointers for future migration laws and policies. Migration is a political and politicized issue, but migration laws do not necessarily have to be themselves. That is to say, it is one thing to have a restrictive migration policy, it's another thing to purposefully make the lives of migrants more difficult. So do not use migration law as a substitute for criminal law or foreign policy. Do not criminalize rescue at sea. Do not use migration laws to punish suspected criminals, and do not try to solve geopolitical conflict over the back of migrants and asylum seekers. When balancing the interests of the state with the interests of the individual migrant, the power of the state to control borders, sovereignty, or national security are in themselves, in my view, too broad and abstract concepts. Societies may also have an interest in regularizing irregular migrations, in preventing economic and social hardship for migrants. Migration law will need to become more flexible. Too rigid classifications do not do justice to the messy reality that I referred to earlier. The reason for which people move are diverse, and so are the people themselves. People shift categories from refugee to skilled worker to first-generation citizen, from smuggled to trafficked person and back, from person in need of international protection to family migrant. We also need to make sure that cooperation on migration takes into account the perspective of transit countries and countries of origin, and acknowledge that one size does not fit all. And we need to stay firmly in defense of human rights, because I'm particularly worried about what is happening to the bedrock of international refugee law, the prohibition of non-refoulement, including at the border. For years now, this is being eroded, with Europe following the worrisome trend set by the US and Australia. The recent restrictive case law of the European Court of Human Rights limits the scope of the prohibition of collective expulsions, and that, in my view, is now being wrongly interpreted as allowing for pushbacks and direct returns. We need to move away from the border control fetishism and look at what happens after entry, and make sure what is necessary for migrants to thrive after their arrival. And that requires equal treatment and clear obligations on both sides. But in the words of Anna Triandafilidou, migration governance need to put center stage the migrant and to seek what migrants do with policies rather than how policies shape migration. So we need to move away from the drawing board solutions and become much more aware of the effect that laws and policies have in practice. And we need to see what works based on evidence. If you allow me, yes. Very quickly. I have two examples here. I'll limit it to one. One very clear example of what I think is a drawing board solution. We're all aware of the disgraceful situation in the hotspots at the external borders of the EU. These hotspots are the direct result of the informal deal between the EU, actually between the member states of the EU and Turkey, turning the Greek islands in de facto open-air detention centers. And now it is the new Pact on Migration and Asylum, in which the EU is essentially proposing to codify and generalize this approach, introducing a border procedure together with the legal fiction of non-entry, with the purpose of quickly processing people and ideally sending them back within no time. But that is only likely to result in more Camp Moiras at the external borders, as people are to be kept in or at the border, short of being locked up. I think that with the activation of the Temporary Protection Directive, the EU has shown to be able to look at alternative forms of responsibility sharing. And I think it's very important for us as migration scholars and public law scholars to actually learn the lessons from that. What is that alternative approach teaching us about, for instance, the agency of refugee and asylum seekers? Under Dublin, people are being allocated to a member state. Under current asylum and migration law, people are being seen as packages that you can move from one place to the other. The worst example of that being the UK-Rwanda deal. So let us look at the activation of the Temporary Protection Directive, look at what went well and what goes wrong, and with that I will conclude my intervention. Thank you very much.
Thank you very much. It was really fast by the end. So now, Mayra, please. The floor is yours. Can we ask for the presentation, please? It's okay. Your presentation is with us.
Yes. Okay. I have my timer. So before starting with my presentation, I want to thank the organizers of the 2022 Annual Conference on the International Society of Public Law for putting together this panel and for inviting me to speak. It is an honor to be here. I can say that traveling more than 20 hours was worthy, considering that the conference amazing guests, audience, and of course my co-speakers. Today I would like to reflect on the impact that immigration law has on public law, and why it is important that public law scholars and students pay attention to this topic. I will argue in this presentation that immigration puts considerable pressure into public law, and in particular to the ways in which a nation organizes its power and defines and ensures the rights of its inhabitants. I will structure my presentation in 3 parts. I will start by critically analyzing 2 of the main arguments that have been put forward to justify the power of nation-states to control immigration. Due to time restrictions, I will briefly explain them. These arguments clearly highlight the tensions that immigrants bring to host society, and in turn, the challenges underpinning the regulation of migration. In a second moment, I will show how this debate has been translated into immigration laws and regulations of northern immigration states. Lastly, I will finish by illustrating how different South American countries have echoed some of these philosophical ideas, starting in 1900 to 2019, when regulating the entry, exit, and residence of immigrants. Immigration brings complexity to public law. It brings complexity because a person that did not live within that bounded territory, that it did not participate in the creation of those rules, is now asking to be let in and to live inside that territory, subject to their laws, but eventually able to challenge and create them as well. Considering the risks and challenges associated with the entrance of newcomers, are states allowed to decide who they want to include? It is possible to justify the power of states to control immigration and consequently on the right to decide who gets in and why on 2 main philosophical arguments. As a way to protect the value of culture and national identity, and as the only means to protect rights and their self-determination as a group living in a particular state. The first argument is about culture and national identity. According to this argument, the state power to control immigration is based on the protection of a common shared identity among the members of the same political community. The existence of the state is based on the idea that there is a common identity among the people that live within a particular territory that ought to be protected from outsiders. According to Walser, a fundamental imperative of the territorial state is the preservation of a culturally distinctive way of life. This culturally distinctive way of life can only be achieved if the political community can decide over its members and non-members. In a nutshell, what justifies the state prerogatives is not merely the control over the territory, but the practices that its inhabitants develop within that territory, practices that express cultural values and can be considered to represent a sense of belonging to a particular place. The problem, as you can see, of this argument is that in today's society there is not one but an unlimited number of cultural communities that have to coexist. In plural societies, everyone is free to develop their own life plan. How are we to morally decide which lifestyle is better? Which kind of life is worth protecting? Another problem of the nationalist argument is that this position has limited resources for preventing racial and ethnic exclusion when certain racial identities are regarded as central to the national culture. In fact, race and ethnicity have historically played a central role in shaping what it means to be an American, British, French, Australian, and so on. Another line of justification for the state right to control immigration draws on Locke's theory of property. The property theory justifies the state prerogative on the individual act of consent. The individual dimension of this argument claims that people make a voluntary agreement with one another to form a state with a territorial jurisdiction. By means of this consent, people justify the political authority of the state and at the same time, the state political authority over the territory where the property right exists. Even when people have failed to consent, Simmons will conclude that when people consent to make or to join a political community, they are also consenting to whatever arrangements are necessary for a peaceful and stable society. From a collective perspective, the consent argument and the state property rights are justified on the self-determination of the group of people that live within a state. The state grounds its authority on the group's ownership of goods produced through the labor and contribution of its member. The problem of the consent and other similar arguments like this, first, is that very few individuals have actually consented to the jurisdictional authority of states, rendering all states illegitimate. Or even when there is an exceptional act of consent, there is never unanimity. Second, in these arguments, there is no account of the nature of the right of property, nor there is a clear sense of what the jurisdictional right of the state is. Are all these discussions merely theoretical? What are their practical implications? Can we see some examples of similar discussions in the regulation of migration in northern immigration countries? I believe this is a lively debate, and each day we see examples or manifestation of these broad philosophical questions. In fact, operators navigate these questions every day, perhaps not even knowing that their decisions are grains of sand that are feeding one or two or more of these arguments. In immigration studies, ideas play a prominent role. Despite the important role that ideas are beginning to occupy in recent migration scholarship, a conceptual framework that compares different types of idea is rare. Pecut, for example, is one of the few that has produced a typology to compare migration policies across 5 distinct philosophies. Even though Pecut comprehensive philosophies can be criticized for presenting north-south migratory dynamics and for being designed exclusively to fit immigration policies of the liberal industrialized democracies of the North after 1945, 5 of its 6 categories that you can see on the slide, the anti-immigration, the national sovereignty, the managerial, the rights, and the free non-governance of migration capture the variety of ideal points in which immigration policies navigate. Let me give you a brief grasp of these different philosophies. On the one hand, the anti-immigration governance that you see on the left is based tries to attain the immobility of immigrants by strengthening control in the country and outside of the state, or through the creation of precarious subjects prone to labor exploitation. On the opposite extreme, there is the free non-governance of migration, which is based on the ideal of the free circulation of people across borders and the elimination of states borders. Although there is some literature that has identified regional agreements, this is mainly a theoretical philosophy. On the other hand, the national sovereignty, the managerial, and the rights-based governance are all philosophies that can be located in between the previous 2 extremes. While the national sovereignty governance, as Jorrit was mentioned, emphasizes the exclusive prerogative of states officials inside national borders, the right governance highlights immigrant human rights, or the liberal principles that justify the individual entitlements that individuals have against the state irrespective of their migratory status. Lastly, the managerial development governance is for Pecut a recent idea that tries to bridge security and human rights concern on the belief that it's possible to control and handle immigration flows and by so doing extracting its optimal results. How these philosophies, and now you question why I'm here, how these philosophies can be used to understand South American immigration policy? Let me provide a very brief general context of how migration looks like in South America. As you can see from the slide, except for Argentina and Venezuela, historically South America has not been an immigrant region. In fact, the average of immigrants coming to this region does not exceed the world average of 3%. Despite early attempts of many countries to promote immigration from European nations, we can see that even today the majority of immigrants come from the same region. What is this regulatory context and why it is relevant? Acosta in 2018 published an historical research on 7 South American countries in which he found certain trends in how countries had regulated this matter. In the 19th century, Acosta shows that South American countries became the precursors of open borders for individuals. The Constitution in particular enshrined clauses guarantee the right to settle and to enter as well as receiving equal rights. But between 1870 and 1930, the region attracted immigrants spontaneously, although we can find a few regulations that had started to restrict the free movement of people. In the 70s, immigration restriction peaked with military dictatorships. In these laws, the foreigner was portrayed as dangerous and a threat to national security. However, after 1980, starts a period of redemocratization. Democracy sealed constitutional reforms that put a spotlight on human rights. The resulting architecture was that practice of external citizenship became widespread, and new immigration law enshrined the non-criminalization of undocumented immigrants and the right to migrate as a human right. So what is the current evolution of ideas of these philosophies in South America? You can wonder how we made these graphics. Using techniques of artificial intelligence, in particular natural language processing, we categorized a sample of 500 out of 3,201 articles of the laws, of all the laws regulating the entry, exit, and residence of foreigners in Argentina, Chile, and Peru from 1900 to 2018, using PECUD's 6 philosophies. In the Q&A, I can go over the methodology if you like. But now here, I just want to show you a brief overview of the results. In the 118 years of legal status and regulation in these 3 countries, we found 4 relevant philosophies: the anti-immigration, the national sovereignty, the managerial, and the rights-based governance. Except for the managerial, which was present for all the historical period and for each country, the rights-based governance appears as a new philosophy that was born in the 21st century. During the first period that you can see on the top of the graph, which corresponds to 1871 until 1920, the mobility of foreigners was not a concern. On the contrary, the management of immigration was a primary motivation to approve laws and regulations. In fact, governors saw it as a part of a nation-building project trying to encourage the arrival of foreigners who could help to populate and industrialize the country. The importance of the anti-immigration philosophy, we can only see it in between 1964 and 1989, which fits with the consolidation of military governments in the region. Lastly, the period that runs between 1990 to the present represents the consolidation of democratic regimes in South America. We find a clear emphasis on the rights-based governance, which corresponds to the adoption of the Convention of the Rights of Migrant Workers and their Families. In sum, compared to other countries, it is interesting to notice that in these 3 countries, and except for the period of military regimes, the anti-immigration philosophy has never been the most important philosophy. The incorporation of restrictions to the free movement of immigrants has moved along with the claim of stronger sovereign powers and managerial conceptions about immigration. These 2 philosophies appear to be working together. In conclusion, in this presentation, I have tried to identify the tensions that immigrants bring to host societies through the revision of the philosophical reasons put forward to justify the power of state to control immigration. After identifying those tensions, I have tried to connect those reasons with the prevailing ideas or philosophies that have sustained the regulation of the entry, exit, and residence in northern states and in Argentina, Chile, and Peru. Summarizing what we have seen, we can say that according to the political philosophers, immigration brings challenges to the definition of the national identity and to 2 key principles in liberal democracies: liberty and freedom. In terms of ideas, and as I've tried to test it empirically in South America, we can see that these challenges have been translated into laws that regulate the entry, exit, and residence of immigrants through 3 main philosophies: immobility and sovereignty, linked to closure to immigration, and to bridging ideas between closure and open, such as the global rights space and the managerial governance. Thank you very much.
Thank you very much. And the last presentation, Carmen, the floor is yours. We are waiting for your presentation.
Can you hear?
Yeah.
We wait for the...
Yes, for the presentation.
Yeah.
Yeah.
Okay, good afternoon, everyone. First of all, I would like to thank the organizers of this 2022 ICONS Annual Conference for having me and for giving me the opportunity to share with you some thoughts about the legal response of the European Union to mass displacement caused by the war in Ukraine. I will also start with a few numbers. As it is well known, on the 24th of February 2022, Russia invaded Ukraine. As far as we are concerned, this almost immediately triggered an exodus of people trying to flee the war and the violence it provokes. Also immediately, the EU and its member states kept borders open and decided to activate the 2001 Temporary Protection Directive. As a result, from the 28th of February to the 28th of June, several million people have benefited from this protection, temporary protection. This is, of course, in stark contrast to the reaction of the EU and its member states to other migration crises they have faced in the past. Indeed, this fast and easy access to protection has not been applied in the past to asylum seekers and refugees from other parts of the world. It seems pertinent to ask to what extent this EU international protection policy can be considered discriminatory or even racist, and for this reason contrary to EU law and the values contained in Article 2 of the Treaty on the European Union. I'm talking about, in particular, of respect for human dignity and human rights, the rule of law, and the principles of non-discrimination and solidarity. Let's start with a brief overview of the EU legislation applied in this case. In 2001, the EU adopted the known as Temporary Protection Directive. According to this instrument, temporary protection is an exceptional measure to provide immediate and temporary protection in the event of a mass influx or immediate mass influx of displaced people coming from non-EU countries who are unable to return for safety reasons to their country of origin. Even if one may think that the EU has faced in the past this kind of mass arrival of people in need of international protection, I think that, for example, some of the images of the 2015 crisis still linger in our minds, and also what happened 2 weeks ago in Melilla, in the autonomous city of Spain in African territory, with a group of people apparently coming from Sudan. All of these images are in our mind, but the truth is that the mechanism of temporary protection contained in the directive has been only activated now regarding the Ukrainian exodus. And it has been activated in a record time. The European Commission proposed activating the directive on the 2nd of March 2022, and the Council of the European Union adopted a unanimous decision in this regard 2 days later, on the 4th of March 2022. So the question seems obvious: is this discriminatory? It is racist? To answer these questions, we have to take into account first that, as said, the temporary protection scheme contained in the directive hadn't been activated in the past, and it was in force since 2001. And secondly, we have also to take into account the personal scope of the Council decision. According to the one adopted in the 4th of March, according to Article 2, this decision applies first to Ukrainian nationals displaced from Ukraine on or after the 24th of February. Second, to stateless persons and nationals of third countries other than Ukraine with international protection or equivalent national protection status in Ukraine before that date, and finally to their family members. This means that other third country nationals can be excluded from the temporary protection scheme. For example, individuals having presented an asylum application in the country or under asylum procedures, or third country nationals with a legal status in Ukraine, such as students, for instance. As a result, a number of racist and xenophobic incidents have been reported during the evacuation of, for example, African students who tried to leave the country, Ukraine, I mean, and enter the EU, and experienced racial profiling measures from public authorities. All this has led to the African Union adopting a statement in which it described the treatment received by African citizens as an unacceptable dissimilar treatment that would be racist and in breach of international law. Also, a group of United Nations special rapporteurs have expressed their concerns about this. And in addition, a growing number of voices from civil society and academia are more or less openly accusing the EU and its member states of discrimination and racism. In any case, and before going on to analyze the possible reasons behind this EU's unequal response, I would like to recall that in a context of massive and forced displacement, the principle of non-refoulement constitutes a basic guarantee, and there seems to be also some consensus that we are talking about a peremptory norm of general international law. This is a jus cogens rule. That is, it applies equally to persons who are not covered by the Council's decision. Be that it may, what is certain is that in the face of a long history of externalization and deterrence measures containing mobility and criminalization of solidarity, the European Union has not hesitated to consider that the conditions for activating the temporary protection directive were met in this case. Even with its protection loopholes and inconsistencies, this means a high degree of legal certainty for the beneficiaries of the measure, especially compared to the legal insecurity faced by migrants and refugees from other parts of the world, Syria or Sudan, for example. So can such an unequal reaction be explained? I will make two types of consideration that are both the conclusions of my presentation and also open questions for further discussion. What is different about the massive influx of people in need of international protection from Ukraine? Well, one obvious answer is geography. I mean, no neighboring country can contain the exodus from Ukraine in this case. Morocco, for instance, is a neighboring, so to say, country that can contain. Another discussion is what is the price we have to pay for this cooperation, but it is a barrier for migrants. And also Turkey is an example, and I believe that the declaration concluded in 2016 with Turkey may be in the minds of some of you. Then in 2016, the parties agreed on 3 key points. First, Turkey would take any measures necessary to stop people traveling from Turkey to the Greek islands. Second, anyone who arrived on the islands irregularly from Turkey could be returned there. And finally, for every Syrian returned from the islands, EU member states would accept 1 Syrian refugee who had waited inside Turkey. In exchange, Turkey would receive €6 billion to improve the humanitarian situation faced by refugees in the country, and Turkey's national would be granted visa-free travel to Europe. Of course, it also sent a clear message. Those attempting to reach Greece irregularly would be returned, while those who waited in Turkey would have the chance to enter the EU territory. I believe that this geographical fact goes a long way towards explaining the European Union's reaction. I don't want to deny the merits of this measure. It is certainly what people fleeing the violence caused by the invasion of Ukraine need, but in my view, the European Union was thinking also about itself. I believe that the mass exodus would have taken place anyway with or without the activation of the temporary protection directive, and as experience shows, the irregularity in the arrival would only have led to disorder, chaos, collapse of national protection systems, especially in the countries bordering Ukraine, and the prominent role of smuggling and trafficking networks in organizing the arrivals. And I think this is something that the European Union and its member states couldn't afford politically. All this led to the EU and its member states to consider legal certainty provided by the Temporary Protection Directive as a global public good, along with the benefit to the population in need of international protection and coming from Ukraine. The measure benefits the EU and its member states and their citizens in different ways. In other words, it generates positive externalities. First, since it would turn in better managed migration flows, member states better control the movements across borders. Second, when people in need of international protection find safe haven, secondary movements of asylum seekers and other people in need of international protection and subsequent border tensions are suppressed. Third, at the same time, it facilitates a more efficient fight against organized crime, meaning smuggling and trafficking networks. And finally, EU citizens would benefit from knowing that the people has found a safe place to be. Nevertheless, as I said at the beginning of my presentation, it is not easy to dispel suspicions of discrimination and racism. And in this respect, I would like to point out that from a legal or international legal point of view, any consideration in this regard must have the application of the notion of racial discrimination in the context of discrimination on grounds of nationality into account, and in particular the doctrine of the Committee Against Racial Discrimination, and in particular its general recommendation number 30, and the recent case law of the International Court of Justice. So it's not only a sociological or political question, but also a legal one. I don't want to consume more time, so thank you very much for your attention.
Thank you very much. I'm going to ask silly questions. Do you have questions from public? Because if we have many, I can skip mine and give you the floor. But if you don't, I'm going with my questions. So the question is, do we have questions from the public? 1, 2, 3. Okay, so maybe if there are 3, 4. Okay, so maybe I'll leave my question for the conclusion, and then let's start with the public so we have time, because I'm a little bit worried that we have only half an hour. So do you agree? Yes? Okay. So please follow the hands. I can see you because of the light, so just decide yourself who was first. Thank you.
Thank you so much for these fascinating presentations, Salomon Stefan from the University of Amsterdam. And the question would go to Jorrit, but kind of like it's also a bit of a broader question to all of you. So kind of like, Jorrit, you pointed out in your presentation that the EU member states have increased cooperation with third countries to curb irregular migration over the past 3 decades. One response by us lawyers was to focus on extraterritoriality. However, member states reacted to progressive judicial decisions by outsourcing more tasks to third countries. So in a sense, kind of like decisions such as the Hirsi and Jamaat case of the European Court of Human Rights served as a blueprint for states to avoid future costs of human rights violations, but not in a sense as we would like as human rights lawyers. So I'm wondering whether we should kind of like refocusing our energy as public lawyers from extraterritoriality to kind of like the public law and the courts of third countries, and to tackle these corporations directly in the countries where they actually do occur, such as Niger or Nigeria or Morocco for that matter. Thank you.
Jorrit, this was the question to you, but please, no longer than 2 minutes, please.
Okay, thank you. No, I think your point is absolutely right. What we saw after Hirsi, the Hirsi case was, of course, we saw that we started massively supporting the Libyan Coast Guard. I agree with you, the solution may be then in the third countries, but that would require that these third countries
have some rule of law, and that's actually the problem. We are working together with a number of countries that have no functioning judiciary, and that makes it very hard to tackle, I think, from the inside those countries. I think that we then do have to go back and look at our own rules on external cooperation, and the legislator and parliament should limit what the European Union and national governments are doing, and should be actually controlling much more the executive inside, for want of the possibility to have that done in the countries of origin. At the same point in time, it's not like these are sort of helpless actors. In some countries where you do have civil rights organization, where you do have some extent functioning courts, you do see this actually, and you see this also in the negotiate or in the relations on return, for instance, where you see a lot of pushback, and rightly so, of third countries. It's not that third countries are helpless, sort of that they undergo the externalization policies. No, they actually shift them into their own agenda. So it's a double answer. I think yes, we need to reinforce structures there, courts, but also civil society organizations in the third countries. But at the same point in time, I think it's up to the democratically elected parliaments to better control the executive in what they are doing externally. I think that would be my answer to that.
Hello, thanks so much for the wonderful panel. And question is to Professor Feddersen Martinez. And so you showed us, I believe it was 12 different time slots representing 3 countries. And you mentioned in your study, a very impressive study spanning more than 100 years for each country, you mentioned that the anti-immigration discourse never really prevailed, if I'm not mistaken. But nevertheless, I couldn't help but notice that in one of the time slots, I believe it was in Argentina, it was really the highest point of all 12. So I was wondering whether you could give us a few more details on what made it really the highest degree of anti-immigration discourse. Was it the language they used? Was it the measures that they imposed against migration? So I would be very grateful for further clarification.
Thank you very much for the question. I wanted to go over each period, but I didn't have the time. But it's interesting that in Argentina, if you compare Peru and Chile in that period, that is the period before the military regimes, you can see in Argentina that the anti-immigration philosophy is higher than the managerial and the sovereignty. And I think the reason why, but this is a hypothesis that I need to go and look at the data strongly, is that in Argentina, in contrast to Chile and Peru, the number of immigrants was much higher. So probably that created a backlash and politicized the matter a little bit. And also there were some anti-immigration groups that probably lobbied during those times, and so the legislation that was in place was focused much more on restricting immigration and perceiving the immigrant as a threat, as a usual threat to the national values, but also to the society. So I think that echoes what was happening in Europe at the same time, but that in South America you don't see as often, because in South America, as I said at the beginning, immigrants were only a small percentage of the population, so politicians did not see immigrants and society, did not see them as a threat to any kind of activity, so therefore the laws were, I would say, kinder to immigrants, and the anti-immigration groups were not strong enough to push for more restrictions in the statutes.
Thank you very much. Hannah Birkenkötter from ITAM in Mexico. I have a question also to Maria. You were offering to explain a little bit more your method of natural language processing, and I'd be interested in sort of like the corpus that you had. So what kind of texts did you analyze? And then how you associated the different philosophical approaches to immigration to sort of like I understand it was laws, and so whether you associated specific approaches with specific legal norms, I'd be very interested in hearing more about that. And to Carmen, I have a question about the CERD, because you mentioned it at the very end of your presentation that we should keep in mind the Convention on the Elimination of Racial Discrimination, and especially General Common 30. I'm wondering, in practical matters, what does that mean? Would you suggest that individuals who have been discriminated against or who have a strong suspicion that the grounds on which they were turned away were racial discrimination should file individual complaints? Of course, this is a very costly and lengthy affair. Or should that rather be done through the state procedures or through the state reports? Is there concerted action from civil society to present reports as part of the state reporting system? So I'd be interested practically, how would that translate into legal action? Thank you very much.
Carmen, can you answer first, and then Mayra?
Thank you very much for the question. Well, in practical terms, we need an international human rights protection body to say that the European Union or states are, So one option in I'm thinking at the same time, but one option is the European Court of Human Rights and Article 14 of the European Convention, okay? And try to build a case, and it will be easy maybe to find some individual who has suffered discrimination because of the application of European or national rules, adopting the European ones. So maybe Article 14 and the European Court of Human Rights. Another one is the European Court of Justice, which is more difficult, in my view, from individuals, but mainly because you have to trust in national courts, making preliminary rulings to the European Court of Justice, and it is long and more difficult. And another path is the United Nations and maybe the Human Rights Committee, for instance, or I don't know, I would have to think more. But I think there are some, so to say, legal paths to have a final decision condemning the European Union for discrimination or even racism, which is not easy, but I think we will see some cases from civil society, some, NGOs maybe, working with migrants and in the domain of protection of human rights of migrants and refugees. I think we will see that in the near future.
As for the methodology, briefly to explain, I can go in more detail after, but what we did is that first we look at all the laws, but also general executive decrees that regulated entry, exit, and residence of immigrants from 1900 to 2018 for Argentina, Chile, and Peru. This is the first year. Now this year we are adding Colombia, Ecuador, Bolivia, and there is always that one that I forget. And what I did, well, there is always methodological limitations. So what I left out constitutional norms. I know maybe I will have to add, particular because in Argentina there is an article that says that only immigrants from a all white immigrants can enter the country. But in this original data set that contained 274 regulations, I left out constitutional provisions and also treaties that were general, because that will, if I'm looking at rights, I can only look at the rights that refer to migration directly, not that if I include, for example, the International Convention on Civil Rights, that would completely change my data set, right? So I only put treaties that refer specifically to immigrants, bilateral agreements, and then domestic legislation. One problem is that I only look at the law in the books and not how the law operates in practice, right? Mm-hmm. And I don't look at discourses either. But this is some way of getting to understand what were the predominant ideas of legislators. So, of course, a future development of this project, I could include the implementation, but that's really, really hard. I will have to do case studies, deep case studies. And what I did is that I took a stratified sample of, I converted all the laws into articles, because my idea was that in each article you can find articles usually are compressed because they share the same meaning. So I transfer all the laws into articles, and then I draw aleatory stratified sample of all the articles divided by period. Why by historical period? Because I knew from the literature that in some periods you could find some ideas that were more represented in some periods than in others. So I wanted to have I wanted to have variation in all my periods, and I manually classified for those 500 articles. I did the classification twice just to be sure that I was trying to fit the philosophies to the letters of the article. And then what we did is that we taught the computer how to learn from the classifications that I had made and to do it to the entire data set of 201 articles. And we got over 65% of accuracy. And we were able to find that because we did a back translation, because we wanted to have the same meaning, but we needed more observations. We back translated the provisions to English and then to English to Spanish, and that way we got more observations, so the computer could learn from those observations and then extract for the entire data set. And I will finish.
I have to say that we have another questions, and I know that
Sorry.
the methodological discussions are
afterwards.
always the best during the conferences, but I recommend you continue, and I collect the questions from the top. Yes. But it seems really interesting with the artificial intelligence even more.
Thank you for all of the presentations. I have about 56 questions, but I will limit it to one per speaker and keep them really short. To the first speaker, I was wondering if you have any insights to share on data protection by the, I forgot the word. Okay, I'll skip that one. For the second speaker, you have already talked about some hypotheses that you have made. I was wondering if you have made any hypotheses that could possibly explain the kind of the difference in the results based on the colonial history of the different countries, whether that in any way could explain differences in your results. And for the third speaker, this is also not a very legal question, but since it's a panel on conflict, I am daring to ask the question. You were asking what price are we paying for containment, and I am wondering what price will we be paying in the future for containment, especially looking at how much money the EU is pouring into Turkey, and what they may possibly be financing with that money. I am really sorry, I'm blacking out on the word that but it's the one where you can put red notices, yellow notices, and data protection related to that, especially in the context of non-refoulement. I hope you get what I am getting on.
I hope you heard the questions, because there is something with the voice.
I'm not sure we hear properly, but I think I understood my question, just in case you can correct me. When I talk about a price to pay for the cooperation of neighboring countries, I mean Morocco or Turkey or any other country you can have in mind, I'm not talking only or mainly about money. I think what happened in the fence between Melilla and the autonomous city of Melilla and Morocco 2 weeks ago is a clear example of that containing migration. It's many times a question of breaching international human rights law for these countries. And it is the same with Libya, for instance, where many incidents regarding trafficking and smuggling and human rights violations of migrants and refugees have been reported, and this kind of reasoning is also in the case law of the European Court of Human Rights, for instance. So I think we had, from a legal point of view, I have, I know what international law and national law in my country says, and I know that these countries are violating the human rights of migrants and refugees. But at the same time, there is a political approach to the problem. I don't know if you are aware of the response of the Prime Minister of Spain. He said it is solved, or something like that, after the death of 35 people in defense. And I think behind that is that he knows that saying Morocco has to improve the standards of protection of human rights means that the following time, Morocco will do that. And we had not 200, but maybe 2,000 people from Africa arriving to this autonomous city of Melilla, which is in African territory, not in the mainland, as you probably know. So I'm not defending the position of the Prime Minister, and only explaining why some politicians prefer to close their eyes, even in, very important incidents like the one. And in my view, it was more or less the same with Syrian people arriving through Turkey in 2015. So it's not only paying money for, do building capacities and so on, but also knowing that we are sacrificing human rights of migrants and refugees.
Yeah, so oh, so you want to respond?
I was just going to say, I think my question came across wrongly, but we can discuss afterwards if you're...
Now I'm even more nervous, because I think you were referring to the whole infrastructure, the electronic border that's being built around the European Union, including this Schengen Information System, VIS, etc.?
No, I'm actually talking about the International Police Organization, Interpol.
Interpol,
Thank you.
Okay. I think I don't know much
You
about
didn't guess.
Interpol,
Okay,
and that's also
thank
very much international police cooperation. So I'm afraid I would have to, I would not really know what to say there. I'm sorry.
Okay, thank you.
Well, I don't know if I understood well, but there are other projects that have compared immigration policies. There are databases that have done that, but I feel that they sacrifice, for gaining general stability, they sacrifice depth. So instead of, and so what I wanted to do with my research is trying to, that's why I look at ideas, because I think through ideas we can get to understanding what politicians think or how they act in different areas, not only like compare different like admission policies or so. And so why I look at the, you asked something about if we could compare this in the European context. So the, or Pecut's philosophy is based on European and North America.
I'm really sorry you couldn't hear or I wasn't clear. My question was whether you have hypotheses that explain your results, especially the different results in the different countries that are related to the colonial history of each of those countries.
Yes. Well, that's why I started looking from 1900, because at that point the countries were independent, so they had their own constitution and their own laws. And so the main focus, at least of these three countries, was to populate the areas, because they wanted to, for example, there were extreme areas of the countries that nobody was living in, so that's why they tried to attract immigrants, so they were that is why they were very open to immigration. And that's why they included jus solis as a general practice. But then after, I would say before the First World War, they started to restrict immigration through the creation of passports, and also they created admissibility criteria to try to leave some people out, like mainly people that were sick or that had committed some crimes. But still it didn't work so well, so spontaneous migration continued throughout the century. And I would say that it changed completely with military regimes where they really restricted the entrance of immigrants, and most people emigrated from these countries.
I see one hand, and then no more. I'm sorry, I don't see you because of the light, but there is probably another questions up there.
I have a question for Jorrit, because I think we heard part of the reply to my question from the professor from Madrid, but I'm interested in your answer. Why is temporary protection activated at the level of the European Union now and not, in the past? Why is that? Is the only explanation, this need to exclude people, not to allow them to enter, even for a short time of 1 year, to give them temporary protection, or other explanations? Because I don't think there was any discussion at the time about temporary protection, really. There was no pressure from some countries like Germany to use this instrument, but maybe I'm wrong.
If I recall correctly, it has been mentioned, and it's very interesting actually that you saw in the new pact they actually proposed a new emergency measure saying the temporary protection directive didn't work because it requires this activation, which is essentially a political decision. Now, I don't think that the activation of the temporary protection directive in this situation was merely an act of the European Union trying to do good. I think there's a very important difference, and that is that first of all, the European Union has been traumatized by all the border closures, the internal border controls that we saw in the wake of the migration crisis. But a much more important element, I think, is that we have this weird thing, the Dublin regulation, that allocates responsibility to the member states, and very often that is the member states on the outside of the European Union. In this situation, we had the Ukraine-EU association agreements, which meant that Ukrainians could have visa-free travel. In that case, that Dublin rule, where the first country of entry is normally the country that's responsible, didn't apply. So I think the cost was also very low to say, okay, you can choose where you want to look for protection. The other element is obviously one that, and it's a very, we speak a lot about discrimination, but it's a different population, and it's people that are closer to us, that look more like us. Now Europe is the region that must have played a role here as well in this decision, but ultimately it was a political decision. But I think that the fact that Dublin couldn't apply the way that it was intended, it never has, but I think that played an important role in terms of the allocation of responsibility.
Okay, the question from the top.
Thank you very much for all the presenters for fantastic presentations. It was very interesting. Елена Прибыткова, University of Southampton. I have two questions, and they are directed to any of you who would be
Excuse me, can you speak up because we barely hear you here?
Or maybe walk? Yes, it's on. Can you hear me?
Yes.
So my first question is, any kind of discrimination regarding people, refugees or not refugees, is absolutely unacceptable. But can we see this level of protection which currently was provided for the Ukrainian refugees as a kind of a certain more or less adequate standard which we might try to incorporate and institutionalize and then apply to further refugees from the other countries? To what extent it is possible in order to avoid this discrimination in the future? This is the first question. And the second one is, what do you think should be the next steps for people from Ukraine? We all believe and we all hope that the war will be going to the end. But what's going to be with all these people? Some of them would like to come back, but some cannot. Their houses are destroyed. They are sick. Some of them received a huge mental trauma. They just cannot come back. Somebody probably through this time will be able already to find a place of work and somehow to integrate into society. Some have family ties and so on and so on. And there are millions of people. What should be the next steps for their protection? Thank you very much.
Thank you.
I think I can respond to the first one, even though I'm not European, but I have in South America, there is a similar experience with Venezuelan migrants, and South America, compared to other parts of the world, has the best refugee system of the world, I would say, because it has incorporated the Cartagena Declaration, which is a statute that incorporates that accepts refugee based on people that are fleeing, for human rights reasons or and lack of protection from the states. But even with the best legal refugee system, when Venezuelans arrived to our territory, we didn't recognize them as refugees. So I would say this is not a problem about the law, this is a political problem, mostly political problem. Because even having the law that you can claim, even if you go to courts, international courts, or whatever courts you want, then it depends on the country and the people that are in power to decide if they want to implement those legal statutes to favor the people that are coming. And in Latin America, you can see that all the countries, Chile, Peru, Colombia, well, Colombia, I think it was more open, Ecuador, but all the countries at the beginning, they received the immigrants and then they created visa requirements and they created temporary status, the same as here. And so I would not say that, and that's why we need to look beyond the law and to see other factors that are explaining these situations.
And the second question, more related to integration, probably.
Well, of course, temporary protection is only one of the mechanisms to give protection to people in need of that. So once they have received a positive decision from national authorities, they will have the right to stay legally up to 3 years. But it doesn't mean that they can apply for asylum, for instance, if they want to stay. So, and I think many of them maybe do that. Otherwise, we will have to wait for the final of the war, and because they have to, even if they want to return, they have to return in safe conditions. So I expect them to, many of them, to stay in EU countries for many years, maybe. And about integration, I think I agree with him. I think integration challenges are maybe less than with other people coming from other parts of the world. But I don't know, because I think it's really early to analyze the results of the application of the Temporary Protection Directive, and I'm sure some of them will return and others maybe will prefer to stay and apply for asylum, which is a more durable, condition.
Yeah, maybe just to quickly add to that, I think that's very important to realize this is an emergency measure of a limited duration and does not exclude the possibility to request for asylum under the applicable EU asylum rules. So ultimately, if the conflict would continue, I would assume that this is actually what is going to happen, that many people will ask for the regular asylum status and will follow the motions there. But what I also think is important to mention here is, I don't think that when we talk about this discrimination, or it's not to say that it isn't fully justified that this regime is now being applied to Ukrainians. It's just that people want to engage with the question, why wasn't it activated before, and what could be the reason for that? But of course, if you talk about discrimination, you always have to look at, are these comparable situations? And that, I think, is the main question. And there's something to be said yes and something to be said no. And then there's, of course, the question that was asked, what are the practical consequences of that then? And that's an even more difficult one.
Last chance for the question. I don't see see any hands. Okay, so please allow me to comment now. Yes, starting with your last point, Jorrit, I agree that, of course, if we compare the 2015 and 2022, it's a big difference if we speak about the legal status of these people coming to Europe, because the directive of temporary protection also gives people the chance to be economically active and access the labor market from the very beginning, which for the integration and the long-term consequences for the individuals might be very important. This is something which is still a huge problem in the refugee camps in Lesbos. I've just visited Lesbos a couple of weeks ago. So there are still visible consequences of 2015 crisis. But going back to your presentation, I would say that there are, of course, a lot of questions related to it. But I agree with you that 2015, which is so-called, in the debate, so-called migration crisis, in my opinion, was also political crisis of the EU, caused by the inflow of people to the European Union. But we should speak more about the crisis of solidarity, the crisis of Dublin regulations, etc. But my very last question to you is, what do you think, because you mentioned the multi-level governance as a model of migration management in Europe, what are, in your opinion, the key challenges in 3 levels, EU, national, and let's say not regional but local, in terms of migration management in time of crisis? I know it's a very big question, but maybe you can list 3, 4 big challenges for the multi-level governance.
Wow.
Sorry about this.
I think the European Union needs to be very careful that it doesn't start, this is subsidiarity and proportionality, that it should, I think at the local and the national level, that's where integration policies, etc., should work. I'm just going to take your question a bit and run with it, and maybe not to answer it completely. What I ended with is, let's have a very close look now at what is happening with the implementation of the Temporary Protection Directive, and let's learn from that. Let's learn that maybe Dublin is a stupid system that doesn't work. Maybe let's learn that we should allow people to work more rapidly, and maybe that is going to contribute to integration. I think when it comes to what should be done at what level, that's a question of competence, and what you see is you see a stronger Europeanization, you see actually directives being turned into regulations, etc., etc. But ultimately the big discussion, I think, at EU level needs to be one indeed of solidarity and responsibility. And from that point of view, I agree with you that the 2015 crisis was a political crisis, and what you saw there, in a way, it was a mirror image of the Euro crisis. It was, you know, the frugal North and the spending South added to that a very nasty element of a division between East and West. I think that's something we haven't discussed yet either. It's a rule of law crisis as well, because we decide something at EU level. We decide to take a certain course of action, whether you agree or not, the relocation decision. And there was a number of member states which simply gave the European Union the finger, let's put it that way. And I think that is something we also need to realize, that if we want to address this common problem together, then we also need to say, okay, we've established a number of rules, we're going to stick by them. And that means that even if I don't agree to them, and even if I'm being overruled, I will abide by it, because that's what we agreed when we decided to join this constitutional order that is the Union. Doesn't answer your question, but I'm going to leave it there.
I know, but it was just a broad question, maybe for the break. Mayra, thank you for your presentation. It was great. It was very interesting from the methodological point of view. And going back to the graph, I would ask you the question related to the Polish situation, because at the moment we have 2 borders. One is the Ukrainian border, open for the migrants coming due to the Russian invasion. But on very few kilometers away, there is a Belarusian border, which is closed, which the Polish government has implemented the law criminalizing the support for refugees from the NGO side. and legalize the pushbacks, which are now regulated by the law. So at the same moment in Poland, we have the very anti-immigration policy, so from the left of your graph, and very, I would say, liberal approach to the other groups. So there are two kinds of selective migration policy. So can you think about an example in which you have two very different approaches to the same group, because we speak about the refugees in both cases, at the same time from your case studies?
Yeah, I think that would be, I didn't look at refugee law in this research. I only look at immigration, economic immigration, but I think even in economic immigration, there are always the two sides. I think, for example, and trying to respond to your first question, what's the philosophy now? I would say the management of immigration is the one the IOM is pursuing, and it's a philosophy that is based on security, but at the same time on human rights. So as you can see, there are many problems about that, but the Global Compact on migration tries to say, okay, states have the right to control their borders, but at the same time they have to protect the rights, they have to create a secure migration for the people that are traveling to respect their human rights. But it's always a tension, and I would say one way that I could think of trying to address this tension in a better way than as we do it now is to have three levels, like prospective, try to think ahead, what will be the challenges so I can anticipate those challenges, then how to deal with reality, because of course you can never anticipate everything, how you deal with the problems that you are encountering, and also what you do with the people that are already living in the countries. Like temporary measures are okay for a time, but you cannot leave the persons living on those conditions forever, and we can see in every country that there are temporary status that are becoming more important, and that creates a lot of problems in terms of access to social services, and so I would say the temporary that creates, that's not a solution, and we have to deal with that maybe through regularization programs, but yeah, it would depend again.
Yeah,
on
I just wanted to show you that at the same time we can be on two different scales. Carmen, the last one for you, it's not a question, but I just want to thank you for raising up the question about the ethics involved in the bilateral agreement with the neighboring countries, but not only, in terms of externalization of the asylum and border policies, which are very important. It's not only about money, it's the big question about ethics, but we don't have enough time to discuss it. Time is out, of course. Thank you very much for all your questions. Thank you for being with us. I would like to thank you, my panelists. It was my great honor and pleasure, and hope to see you somewhere. Thank you.